Welcome to Too Many Lawyers. I'm Royal Oaks.
And I'm Connor Oaks.
And if you're new to the show, I'm the dad, Connor's my son. We've been doing this every week for about 7 years, and we haven't agreed yet on anything. So that's weird. Maybe we've set a world record.
Well, that's kind of the point of the show. Yep. We've got the elder statesman, boomer.
Well, thanks.
We've got the...
How about middle-aged statesman?
The young buck, youthful energy millennial over here who brings so much to the show. Yeah. Me specifically. And we, like you said, always disagree, or almost always disagree. We are, after all, both lawyers. So we have that shared legal perspective, and we very frequently understand each other through the language of the law very well.
But the whole point is we want to avoid the toxic partisanship that has infected the society and the entire galaxy over the last several years. How long since Trump's been in power? Anyway.
A little bit before that, unfortunately.
So if you're a longtime listener, thank you. If you're new, thank you. And we want to talk about cases being dismissed or
it's the dismissapalooza this week.
Defendants possibly being happy in three contexts. There's the famous Jussie Smollett.
Of course.
We got some good news recently. His conviction, he served 6 days, I think, but then he challenged the conviction, just, for the heck of it, and it got tossed out. And then, of course, there's Donald Trump, who's jumping up and clicking his heels with his ruby red slippers.
He and Elon both are very good at jumping.
Yeah, that's right. He does leap because a couple of federal cases are being dismissed. And also, we're going to talk about the Menendez Brothers.
Of course.
They're hoping for resentencing and to be free, to get out on Mosher Boulevard and shop at Rodeo Drive. So those are the topics. Let's start it off with Jussie Smollett. Just a bizarre, weird case. I mean, setting aside the oddity of, oh, gosh, I'm hungry. Yes, it is Chicago in February, 3 a.m., and it's 87 degrees below zero.
Right.
But doggone it, I'm going to walk because I like the hot meatball sandwich.
Sure.
So anyway, they convicted him.
Look, if you're smart enough to try to fake a hoax hate crime to increase your public persona and visibility, you're not, unfortunately, smart enough to do it well.
That's true.
It's our saving grace as a society that criminals are so often dumb.
So if you don't remember the Jussie Smollett facts quite as well as you know the Menendez Brothers facts, because you've seen the Netflix special several times, Jussie Smollett was convicted, and I think he got a year or a half year, but he served 6 days. And then they said, oh, I think we have overcrowding or something, or you've got a really rich and famous lawyer, go with God. And he was out. But, to clear his name, he appealed the conviction.
Yeah.
And guess what? The appellate court said, the conviction is out because the prior DA made a deal kind of sort of with you, and then the state attorney general, the new prosecutor in town, came in and said, I got jurisdiction. It's like one of these police procedurals on TV.
Get off my crime scene.
And he said, I'm not honoring that deal.
Right.
So how was your reaction to the fact that this conviction was tossed out, and it's like having a pardon?
Yeah, it really is. Except you don't have to accept and admit guilt the way you do to accept a pardon. Yeah, this is a case where I think a lot of people are immediately, their first intuition is, oh, celebrity justice. Once again, the rich and powerful actor with really good legal representation gets off on a technicality, walks for no apparent reason. Well, silly as it may seem, he didn't walk. He actually did, air quotes here, serve his time, 6 days. But this is about vacating the conviction after the fact. This is a guy who was promised a deal by a district attorney. And when you're promised a deal, this is an inducement to do something that's to your detriment, right? You're supposed to plead guilty generally, and that would have been the deal that he was offered. And for pleading guilty in a very public proceeding and admitting that you'd done this, you therefore receive the benefit half of the state doesn't have to prove that you did this wrong. And the deal that they offered him was very easy to accomplish. We're talking 16 hours, I believe, of community service.
Grueling hours of community service.
Right, serving in a soup kitchen or something.
Which
maybe
basically would have consisted of people coming up to him, fawning over him, asking for his autograph. Oh, my God, it's Jussie.
Yeah.
Yeah, that would have been arduous.
Pretty rough, yeah. And also, he had posted a bond to get out of jail, and it was $10,000, and so he agreed to forfeit that bond, not get that money back. Okay, so he basically pays a $10,000 fine and does an extremely minimal amount of community service.
That was the proposed deal.
And that was kind of how people were thinking of this bizarre circumstance of what he'd done. After all, and this is a strange way to say it was a violent crime he faked, but it wasn't a violent crime he did, right? Staging a fake attack, fake mugging, or fake hate crime or whatever on yourself is not inherently, dangerous to the public. It's not like this guy's
publicity. Mission accomplished.
Yeah, he certainly got it. And certainly, I think he got more than he bargained for.
You okay with him being released, or his conviction being reversed?
I am constantly, sort of almost obsessively, when I look at these public justice cases, I am so concerned with overreach by district attorneys, right? When you have the prosecutors who are flexing their power and abusing the imbalance between themselves and a criminal defendant, I'm constantly worried that they're going to overuse that imbalance and that power dynamic and get people to take bad deals. Because overall, throughout the history of this country and up to the present day, that is most often what happens. And people will say, oh, well, it's bad, it's wrong that the richest and most powerful among us seem to get the best deals out of this circumstance. And I'll say, yeah, that's exactly the problem. The difference between you're treated as a Jussie Smollett versus a small-time petty criminal with no good legal representation, a very overworked public defender, and the deal you get, that is my point, that this system is inherently unfair. But I'm not going to fault the guy who gets off on a technicality for this. Okay, not innocent, not really victimless, but not that bad crime. I'm going to say
few people died.
Yeah, exactly. Few people died. So let's think about perhaps giving a better deal and keeping the district attorney honest, making sure they don't lie or give tricky deals, pull the rug out from under most people.
My first reaction is I'm just delighted that our perfect record is still intact.
Oh, good. Thank goodness. Of disagreement, of course.
We disagree. So here's the deal. There was no deal. The DA said, well, how about 16 hours and forfeit your $10,000?
Is that a Chicago accent? Is that your best Chicago accent?
I don't know. I think it was Mayberry RFD. It's a bad Gomer Pyle. Sorry, Jim Neighbors, the dead Jim Neighbors. No, the arrangement, the proposed deal was that, but it was never finalized. It isn't a deal until the judge says yes, because it could have been a horrible onerous deal where it says you're going to break big rocks into little rocks, Jussie, for 87 years.
It's true.
And Jussie says, okay, I'll go along with that. Really? Okay. I'm going to get promoted in the DA's office.
Right.
But it isn't a deal until you go to a judge and the judge says, I sign off on it.
Yeah. No, you're absolutely right.
It never happened. So what happened then, while they have this proposed deal, is that the state attorney general in Illinois comes in and says, I'm the new sheriff in town. I'm going to prosecute this.
Right.
And there's no deal. He's convicted, and he appeals the conviction. And the Court of Appeals there in Illinois said, that's not fair. They really kind of sort of halfway had a deal, and maybe they had the same theory that you had.
Right.
But they didn't have a deal. And so, he served 6 days because of overcrowding. I guess the Cook County Jail is so filled with politicians, there were no empty cells for Jussie Smollett. But so they let him out. So this was all just for his.
Is that where they're holding Blagojevich? Is he still in behind
bars?
bars?
I think didn't Trump pardon him?
Oh God,
I think
he did.
he's out.
You're
but the bottom line is that I don't think that they had to honor that. I think it was wrong for them, just as a matter of principle, to say your conviction is vacated because he didn't have a deal.
Yeah, there's a similarity and there's a big difference between this case and the Bill Cosby case.
Absolutely.
The similarity being, of course, that we're talking about a plea deal that then kind of gets clawed back by the district attorney that comes into office after the original DA made the offer of the deal. The difference, though, is exactly what you highlighted. With Bill Cosby, the reason he walked is because he took the deal from the district attorney. He testified without pleading the fifth, that is, asserting his constitutional amendment, Fifth Amendment right. to against self-incrimination. He testified openly in the civil case based on the promise that he would be immune from criminal prosecution. And then the new DA rolls into town and says, "Psych, we know you acted to your detriment and relied on this deal and testified, but we're going to now prosecute you criminally anyway."
But actually, I think it's even better for your position because.
Do tell.
Analogous to the Jussie Smollett deal, the arrangement that they made with Bill Cosby apparently wasn't really kosher. It didn't follow all the rules. So essentially what the first DA years ago said was to Cosby, look, if you will just agree to not take the fifth in this civil case for rape, sexual assault by Andrea Constant against you,
right,
and instead give your deposition, and this case will go forward, and then you'll either settle it or you'll go to trial, you'll win, you'll lose. If you do all that, I won't prosecute you. And in reliance on that,
right,
he went ahead and testified, gave the depo where he said, yeah, I used quaaludes to seduce women.
Seduce, yeah.
To have sex with women.
Yeah.
But the point is, it wasn't a done deal per the rules there in Pennsylvania. So in that sense, it's kind of like Jussie. And
the new DA got to come in and say, we never got the say-so from the judge.
So a flawed deal.
Yeah. And
the Pennsylvania Supreme Court, ultimately, just like Illinois, said, you know what, it wasn't fair that they went after Bill the second time, given the fact that he relied on this sort of imperfect half deal. So
now
both courts came out the same way.
Give the most extreme devil's advocate version. Talking to the new DA in the Cosby case, I'm sure he would have said there are lots of reasons why Cosby testified in that case. One, he may have relied on the fact that he thought he was then going to be immune from criminal prosecution. I think that's probably a pretty big one, big reason why he testified. But people testify in their cases all the time. He maybe thought it was going to improve his chances in that civil case. Given how the testimony went in that deposition, I don't know how it possibly could have improved his chances in that civil case. But very frequently, people go into depositions thinking, I'm going to knock this out of the park. I'm going to testify, and everybody's going to understand my position.
Learning and delivering lines on TV, you think he would have done better.
Yeah, I have deposed several actors because I practice in Los Angeles, California. So guess who is out there driving around, getting injured in car accidents and needing a defense in my cases? Very frequently, it's out-of-work actors currently working at Starbucks.
How did Jack Nicholson do?
And they're unfortunately not yet Jack.
Yeah.
Jack, call me anytime, and believe me, I will quit my entire job just to represent you personally, but not yet.
All right, when we come back, we're going to talk about the Menendez brothers. We're going to talk about Donald Trump getting off the hook on his federal cases. Stick with us. This is Too Many Lawyers. Welcome back. This is Too Many Lawyers. I'm Royal Oakes.
And I'm Connor Oakes.
And we are talking about cases going away, criminal defendants being happy, or at least potentially being happy. We just talked about Jussie Smollett, who's, I'm sure, is celebrating after serving 6 days in jail. Now the conviction is wiped out. We want to talk about Donald Trump being very happy about his federal cases, and also talking about the Menendez brothers, which is something everybody's talking about these days. So let's talk Donald Trump first of all. I mean, after all the nasty things Donald Trump said about Jack Smith, he's a thug, he's deranged, he's a mental patient. I'm going to fire him the first day, not just the first day, probably first minute on January 20, 2025.
Yeah, I'm sure Jack's shopping the resume around. He's probably asking some of his old buddies, hey, you got a spot at the old law firm?
So Smith is the guy running the show in the Florida Mar-a-Lago case. And, of course, that was dismissed by the judge that Trump appointed. But Smith has appealed that, and that could easily get reversed. So it is still a live case. And then there's the January 6th case, election interference, incitement of the riot, and so on. And that was very much alive, even though, as we know, back on July 1 of this year, this U.S. Supreme Court said, hey, guess what? Donald Trump is immune from criminal prosecution with respect to core constitutional duty type stuff. Yeah. So Jack Smith comes up and he says, I'm dismissing both of them. And so he's going to court in each case. He's abandoning the appeal in Florida, and he's already gone to Judge Tanya Chutkan, who's presiding over the Washington, D.C. case. What's your reaction? And do you think maybe there's a little bit of sneakiness in the sense that the judge in Washington, D.C. said, okay, Mr. Smith, I will dismiss the case without prejudice.
Right.
Meaning, in the future, if you want, if the rules permit it, you can try again.
Right. Yeah. So this concept of dismissal with or without prejudice sounds inside baseball nonsense, because it is inside baseball nonsense. The language is very strange, but imagine your rights are prejudiced by a dismissal with prejudice, right? You are affected by that. A dismissal without prejudice means you can turn around immediately and refile. Say it's a civil case, you get dismissed, you can turn around and draft a new complaint and file it and serve it on the other side and restart the whole lawsuit process.
Yeah, and in a civil context, it's kind of like the judge looks at a case and says, your case sucks.
Right.
I'm dismissing it.
Something wrong with it.
But it's not so fatal like the statute of limitations you're suing over the shooting of Abraham Lincoln.
Yeah.
I'm going to let you, refile it down the road if you feel lucky and you feel smarter.
And that's a great example. If the statute of limitations has run, that is something that is final. That is something that cannot be remedied by a refiling alleging new or different facts. But if you say, that you're dismissed, your claim is dismissed after you bring you bring a complaint, and the complaint says that they breached a contract against me, but it doesn't give you sufficient details. The pleading itself is very vague. The judge might grant a motion to dismiss and say, you got to come back with more facts, right? Come up with the reason why this was. Give me the dates that the contract was supposed to be completed on. Give me your side of the contract and that you completed your side of it. All the other elements of breach of contract that might be trotted out. So that's what dismissal with and without prejudice is all about.
So what do you think the chances are that in 2029, after Donald Trump leaves his second term, assuming there hasn't been any,
constitutional amendment,
impeachment and conviction shenanigans between now and then, what do you think the chances are that Jack Smith or his grandson, if he takes over the job by then, will say, "Oh, remember me, Donald Trump? We're going to trial against you after all."
Yeah, I think the chances are good. I think that there will be a lot of political will.
Even though he'll be like 83?
I mean, so was Cosby, right? There's a lot of political will. There's a lot of animus against Trump. And if Trump, I think, changes his entire personality and becomes a great president, and everybody sort of grows to like him and he unites the country around him, some other nonsense that's not going to happen, then maybe that political will disappear. But I think there will be a lot of people, his political opponents, who rightfully so say that this guy should be at least face judgment and have juries or judges, depending, determine whether he broke the law many, many, many times in front of all of us on TV. Actually, we all saw it, but that's not the point. That there's going to be enough political will. The question is, are there going to be statutes of limitations that have run while he has been president?
But probably not, because when you're president, Jack Smith's whole point is, I can't prosecute a president while he's in office.
Right.
And if you're prevented from prosecuting, I think the statute of limitations, as they say, will be frozen, put on the shelf.
This specific application of the tolling of a statute of limitations is absolutely untested waters. We do not have precedent to look back on. We only can think what courts do in that situation when there's no precedent to work off of. They say, well, what should the result be, right? It was dismissed here specifically and exactly because he was going into office as president and thus will be immune from prosecution. So I think it's a very good argument that if you look at Jack Smith, why is he doing this? Why isn't he just sort of putting it on the shelf? Why is he actively dismissing it? Well, maybe because he thinks it will make his argument for a tolling of the statute of limitations stronger, because 4 years from now, he will be able to say to whoever the justices of the Supreme Court are at that time, God willing, they're different. He says to them, because he'll probably get to them eventually, I dismissed this case specifically because he was about to be president, and therefore, obviously, the statute of limitations had to be told. In the same way that if somebody has a civil case and they have a right to bring a statute of limitations and they're in prison, they're in a coma, or they're too young, they're not 18 years old yet, it's told until the right matures or they're capable. I mean,
and if you're a comatose prisoner who's age 14, that would be like a trifecta.
Triple whammy. If you are 4 years old and you're bitten by a dog or have a car accident or whatever, the statute of limitations for you to file a lawsuit for personal injury is usually 2 years, in California at least, but it will be told until you are 18.
So let's switch gears to talk about Stormy Daniels. This isn't a prosecution. This is a conviction already in the book.
True.
The judge is about to sentence him. He puts it off several times.
For the hush money payment,
AG District Attorney Alvin Bragg in Manhattan is saying, well, we're going to put this off indefinitely. To me, there's an even greater chance that Bragg will try to say in 2029, hey, indefinitely is over, Your Honor. 34 felonies.
Yeah.
I want this guy to go to prison, or at least for you to declare a sentence, even if it's a suspended sentence.
Right.
It seems like it's more likely than Jack Smith to succeed than Jack Smith, because Jack Smith doesn't even have a conviction yet.
Yeah, it does make sense that at this point we're 99% of the way, right? We're almost there. We're almost across the finish line. We're on the 1 yard line of Alvin Bragg getting a sentence against Trump in this situation. So if you've got to be put on hold at the 99th percentile at the 1 yard line, it is much more likely that that process starts back up again, as opposed to in the Jack Smith case, you're going to have to go through the whole point of statute of limitations is that witnesses disappear, they become unavailable, their memories get fuzzy, documents disappear, evidence that you might be able to use in your defense. Trump has no argument in the cases where he's already convicted that he won't be able to mount an adequate defense because of the expiration of a statute of limitations, the way he has in the Jack Smith cases. So I think you're absolutely right. It's a much stronger argument that Bragg should be able to resuscitate this in 2029.
2029. All right, let's get to our final topic, and that is the Menendez brothers, the topic everybody's been discussing. You had this TikTok campaign where people said, release the brothers, believe survivors. Then you got the Menendez Netflix special. Then you had the dramatization with Joaquin Badim. I'm messing up his name.
I believe you. There was the Peacock series. Yeah. There was the Netflix version was Monsters.
Chloe Sevigny.
No one can pronounce her name. Don't feel bad about that.
Anyway, the bottom line is there's so much intense interest in whether these guys really were abused. I think most people think that they were. There's a tsunami of evidence. But, does it really justify them being released? It's sort of like the question of believe all survivors, but do you release survivors who chose to execute their parents? So that's the emotional issue here. But the context is that the very progressive district attorney in Los Angeles County, George Gascon, recently, some people say it was a Hail Mary pass to try to get reelected, and he lost badly. But he came out weeks ago and said these guys have served their debt to society. They've been rehabilitated. And Connor, the interesting angle here is that the legislators in Sacramento, California, are so progressive that they have passed some very liberal sentencing rules recently. And one of the resentencing rules they passed 2 years ago said that any judge who is responsible for a case involving these brothers, for example, may resentence them, even though they were sentenced to life without the possibility of parole, for various criteria. One is, have they been rehabilitated? Another is, are they violent? Are they a danger to society? Third, have their rights been infringed? Is there dramatic new evidence? And now, wait for it, is also, did they have childhood trauma? That's in the statute. And very few people know this. This is like the poster child for the Menendez brothers case.
It's like
how can they not succeed with their background, with the evidence of childhood trauma?
It's like this law was written for them. I mean, for this circumstance. Meaning, of course, horrifyingly, that this circumstance of people suffering childhood trauma and then continuing a cycle of violence is very, very common. But that law, as I understand it, applies to people who committed their crimes before they were 26 years old, which the Menendez brothers fit too. I mean, it is really a very specific statute.
That's actually a little bit different. The statute I described is a pure resentencing statute.
Gotcha.
And the concept was, rehabilitation is really, really important. Childhood trauma is really, really important. And even though everything went just fine in the court proceeding, we think that a judge should be able to say you're out. The separate statute you're referring to was actually 4 years before that. And what it said was, if you are convicted of murder and sent to life without possibility of parole, but if you were under 26 when you did the bad deed, after serving 25 years in prison, you're entitled to go to the judge and say, Your Honor, I want to go on parole.
Undo my whole life without parole thing.
So two separate, very progressive, pro-criminal defendant statutes. And some people who are learning about this aren't real happy about it. And, I'm always talking about the initiative process in California. And it strikes me that the people of California are just different from the legislators. The people of California, when they go to vote, did three things in recent years. Number one, they said, we like capital punishment, keep it. Number two, we don't like affirmative action, let's get rid of it. And number three, very recently, minimum wage increase, forget about it, we don't want it. This is not progressive. This is not what comes out of the legislature. The legislature came up with those two sentencing rules that I described, and it sounds like you're okay with them. I'm not so okay with them.
I'm definitely okay with those sorts of sentencing rules. I think that those very complicated multi-step processes, multi-test multi-step tests that need to be applied by judges and parole boards to allow more lenient resentencing or allow parole where otherwise they would not be eligible. Those are really complicated, bureaucratically difficult to wade through processes that are probably not going to have too many false negatives that let violent offenders who shouldn't be out. And they're overall going to generally, slowly provide new paths for folks who have been over-sentenced and over-criminalized by overzealous DAs in the past to claw their way back into society, because we see more and more, at least in my opinion, and I think in the literature, that rehabilitation is in many ways possible. And so that animates me. That is my animating principle, that I think we want to aim towards rehabilitation over, the punitive value of and I'm not disputing that there is punitive value. I think that criminals, having to go through a difficult time, is good for society morally, to see that wrong actions are punished and all the rest. I'm less trigger happy on the punitive value of, but this is sort of a philosophical argument about the nature of punishment. Here we have these folks who seem to me very likely. It is my opinion that Nathan Hochman is how you pronounce his name? Hochman, thank you. I see it as very likely that Hochman will ride into office on his commanding victory over poor George Gascon. R.I.P. I voted for you. I love you, George. I wish that you had a more of a chance. I think you got a raw deal, but Nathan will probably roll in and say, yes, I'm going to ride this wave of popularity, and as one of my first acts, take over and continue the process of endorsing and saying these folks should get a resentencing and should potentially even walk free.
And if they do get resentencing, they will walk free, right? Because whereas the murder in the first-degree conviction led to 25 years to life, and it was life without possibility of parole, the resentencing will almost certainly be, we're going to kick it down to manslaughter. And manslaughter, it depends. It could be 2 for less than 10 years in California.
Right.
They've already served 30 years, so they're definitely going to be
And they're probably going to meet a bunch of the other requirements, as you described, things like rehabilitation. I didn't watch them do it, but allegedly they participated in a lot of really positive rehabilitatory work, could be helping other prisoners, that sort of thing.
It's interesting that you focus on that point, because the DA really made a big deal at his press conference weeks ago about how these guys have really done wonderful things.
Right.
Have programs for other inmates that could have just been sullen and withdrawn into themselves, but they've done a wonderful series of things behind bars, and so rehabilitation is a factor. It's interesting that Mark Garagos, the lawyer for the Menendez brothers, he's not pushing that so much.
Interesting.
Instead, he's pushing the fact that the family wants the boys home.
Oh, huge deal,
There was a 90-year-old sibling of one of the dead parents who is saying, no, don't let them out. But virtually everybody else in the family is saying, let my people go, including a sibling of Kitty and a sibling of Jose, both of whom have testified in court now within the last couple of days. And so that's really being pushed by Mark Garagos, which is surprising to me because, frankly, I think that's the least important element. If they were rehabilitated, if they were denied rights, if there's new evidence from the Menudo boy band thing, it's one thing. But the fact that the family wants them home, for all we know, the family hated Kitty.
Right.
Siblings hate siblings sometimes, even if the siblings aren't molesters.
Sure,
But I guess it's a factor. Mark Garagos is a very fine, experienced criminal lawyer, so maybe he knows what he's doing.
Yeah, to me it does feel like kind of a cherry on top, and you should be really focusing on the sundae. If you've got the other components of the sundae, and focusing on the cherry makes me suspicious that your vanilla might have turned.
Yep. All right, we've done it. We've gotten through all these cases, and I think we preserved our perfect record
of constant disagreement.
Don't really
absolutely.
Agree on a whole lot.
Well, we both like the Dodgers. That's something.
That's true. That's true.
Is that all we got?
Program note: we've got Marcia Clark, the prosecutor from the O.J. Simpson case from back in the day. I'm going to be interviewing her on Too Many Lawyers in a few weeks. And if you've got questions for Marcia, I'd love to hear from you, because I've got my own, having lived through the experience.
I've got questions for Marcia.
All right, but if you've got them, there's an email. It's royaltalkslaw@gmail.com. royaltalkslaw@gmail.com. Send me the questions.
Also, sign him up for any mailing lists you come across. Just put that email address in. He'll really appreciate that.
Absolutely. Thanks for watching. We'll see you next time on Too Many Lawyers.